Hello and welcome back to our YouTube channel. Well, it is lecture number 29 of Indian Polity today, and the date is 16th July 2025. Well, in today's discussion, we are going to discuss the Indian elections. We will take two classes for Indian elections to understand it with respect to your prelims as well as mains. And whatever is important in this topic, we will try to discuss that here. And this would be the last, topic which we have to discuss with respect to Indian polity. And after that, we will start the another subject, which is the governance, which is also a bypart of Indian polity. We'll start from tomorrow or day after tomorrow. We'll start the governance here. So before we'll start our discussion today, I would like to give you the brief introduction about this initiative, so that if you are new to our channel, you will get more connected with us. Basically, from 2nd June, we had started an initiative by the name Target IAS 2026. Under this initiative, every day we upload two videos. One in the morning session where we discuss your current affairs, we discuss the daily news analysis, and we discuss them in a way, we discuss the important articles in a way that if it is relevant with your prelims preparation, we frame the possible prelims questions there. And if it is relevant to your mains preparation, we do the discussion based on your mains requirements. So everything is covered in the first video with respect to your current affairs. And in the second video, which is this video, we discuss the static syllabus, and we are currently discussing Indian polity and we are about to complete it. And here we had promised you that by the month of January 2026, most probably we will complete your full syllabus, whether related to prelims or mains. Everything will be covered here except the optional subjects. The optional subjects we are not going to cover here. And one more thing which I want to add here, that as we are preparing these lectures for you, as we are delivering these lectures for you, at the same time we are preparing your notes for each subject. Currently we are preparing for Indian polity, and they would be very soon available to you guys. These notes are very much different from your conventional books because they are written in a different way. After every topic there is a prelims model question as well as mains question if the topic is relevant to the mains exam. So if you want to get the service of our notes, you just have to mail us, and then you would be told to pay 200 rupees per subject. It is up to you if you want to get the service or not. Rest, this is the initiative. If you want to be the part of it, please do subscribe the channel, do share it with your friends so that they may also get benefited from this initiative, and please do write in the comments what else should we bring for you guys. Now let's start our discussion here with the elections, Indian elections. you know One thing, if I will ask you a question before I will start the discussion, what are these elections? The most common answer which I can get here is that the elections, it is the way by which we elect the government. The elections, we can say that the elections, it is the tool through which we elect our representatives. What is the election? It is the tool through which we represent our representatives. We elect our representatives. So it is a tool. We elect our representatives, people, and then we hold these representatives accountable. How we can hold them accountable? In the next election, we will not vote for them. So this is, in a way, the election is a tool in which we elect the government, and at the same time we, if we are not happy with them, we reject them and we throw them out. And is it only is this much what elections are all about? No, elections, the elections which are in our country, which are conducted in our country, this is not only about the to elect the representatives. It is not only about to elect the government. It is also about to keep the government on check. When the government is in business, when they are elected for 5 years, how we can keep them in the check? We can keep them in a check. In this way, we will also elect the opposition for them. We'll also elect the opposition for them. For example, in 2014 elections, we elected the BJP government and we had full faith in them. In 2019 elections, this faith reached to the climax. We elected them again. There was almost no opposition during 2019 elections. But in 2024 elections, what we decided? We decided one thing, that let's keep some check on them so that our questions would be answered. For that purpose, what we did, we distributed our votes. We gave 99 seats to Congress, so that Congress will act as a strong opposition to the government. They will ask the questions, they will restrict the government. So what is this election? This election, if we will define it, the election is a process, it is a tool by which we elect our representatives who eventually become the government. So we elect the government, we keep the government in check. After 5 years, if we are happy with them, we will keep them in there. If we are not happy with them, we will throw them out. And also, if when the government is running, when they are running in their term, what we do, we elect the opposition for them, who will keep them in the check. So this is the way, this is the simplest way we can define the elections. In the simplest way, it is a tool through which we elect our representatives. But election, if we will see the election, it is the characteristic of a democratic system. The elections in itself are the characteristics of a democratic system. But how we can say that, for example, even Pakistan, they claim that they are the democratic country. But can we say that, are they really the democratic country? What will define whether a country is a democratic or not? It is the way elections are conducted. It is the way elections are conducted. There are certain features in the elections. If those features are fulfilled by any country, then we can say that the country is fully democratic. So to claim the status of a democratic country, you don't need only one thing, that there should be elections. Elections should be there, but with certain features. What are those certain features? Let's try to understand those certain features. First feature of an election is it should be free. It should be free election. Everybody should be able to participate in it. Almost everybody, whoever is allowed to vote, he should be able to vote. Whoever is allowed to contest the election, he should be given chance to contest the elections. There should be no arbitrary ban on anybody. So it should be very much free. Second, it should be very much fair. The election should be very much fair. There should be no uneven support to any political party. For example, if we look in the Pakistan, we'll take the example of Pakistan. In 2024 elections, which was the political party which should have won the election? It was the Imran Khan's political party. But he did not have the support of the establishment there. What happened to the results? It was totally fabricated results, and eventually the political party, which is the puppet of the present establishment there, they came into the rule, and it was declared they had won the elections. So there is no fair election, there is no free election. Then we can definitely say that the democracy is nowhere in the Pakistan. But in India, if we compare, there is free election. Everybody who has attained a certain age, he is able to contest, to vote. He is given the chance to contest the election, and there is fair election. There is no support to the political party in government. There is no such support to them. So definitely there is fair election too. Then what is the third criteria of an election, of a country to be a democratic? If the elections are held periodically. If the elections are held periodically, then we say that it is also a criteria of a democratic country. It is also a feature of a democratic country. Suppose there was a country, let us suppose if in our country the elections would have been held after 50 years and they were very much irregular, then can we call that our country is a democratic country? No, we cannot call. There should be a complete check on that, very timely check on that. It should be, the elections should be held after certain time period in which the people can decide whether to keep them in the office or to throw them out. So if these features are present in any country in the elections, then we call that country is a democratic country. So elections don't define only through the elections we don't only elect the government, we also, it defines very much about the country, it defines very much about the society, it defines very much about that particular area, what is the mindset of those people, how they are governed, and what type of questions can be asked to them. So it tells a lot about the people and the country. So this is about the election. This is in a nutshell about the election. Now we had understood the features of the election. What are the key features of the election? Then we can call there is a free and fair election. Then we can call it is a democratic country. We understood it. Now let us see what does the constitution say about it. Let us find out what are the various constitutional provisions which discuss the election. Let's try to find out that, so that we'll get the idea about it. You know, there is a question, a question may come to your mind about right to vote. Is it a constitutional right or a statutory right? For longer time there was a confusion. There were two blocks in this regard, that right to vote is not a constitutional vote, because we have article 326 which talks about sorry, we have article 326 which talks about universal adult suffrage. It does not talk that everybody has this right to vote. It talks about universal adult suffrage. So there was confusion whether the right to vote is a constitutional right or not. But in 2016 the Supreme Court cleared this, that right to vote is a constitutional right. So coming back to our discussion, let's see what does the constitution say about the elections. What are the various constitutional provisions regarding elections? For that we have articles from article 324 to 329. First we will see them. We will just randomly know what they talk about. Then we will describe, and then we will discuss with respect to means perspective, what is election commission, what is its role. First here we will just find out what does these articles talk about. We have article 324. What does it talk about? It talks about the superintendents. It talks about the direction. It talks about the conduct and control of elections to be vested in Election Commission of India. So what does article 324 talk about? It talks about the superintendents. It talks about the direction. It talks about the conduct. It talks about the control of elections to be vested in Election Commission of India. About Election Commission of India, we will see how it has evolved in our country. So this is article 324. It talks about the superintendents. It talks about the direction. It talks about the control of elections, conduct of elections to be vested in with the Election Commission of India. What are these elections? It can be the election of the president, it can be the election of the vice president, it can be the election of the legislative council, it can be the election of the legislative assembly of a state, it can be the election of the Lok Sabha, and it can be the election of the Rajya Sabha. So these elections are under whose control? They are under the control of the Election Commission of India under Article 324. This is what Article 324 says. Superintendents, the direction, the conduct and control of elections to be vested in the Election Commission of India. Please remember this much for now. Then we have Article 325. Article 325 says that it talks about the common electoral roll. Article 325, it talks about the common electoral rule. If I can ask you a question here, but I know you cannot answer it, it is not a live session, but for the interaction, which decision of the British India was the majorly reason for the partition of India? It was the Morley-Minto reforms in 1909. Morley-Minto reforms in 1909, when there was a separate separate electoral roll given to whom? There was a separate electoral roll given to Muslims, and at that time this comment was made, we are sowing the dragon's teeth, which eventually will lead to the partition, and it resulted into the partition of the country. So what does this the framers of the constitution were very much aware of it, what happened because of the Morley-Monty reforms in 1909. So because of that they were very much aware of it, and for that when they created the constitution, when they were framing the constitution, they made it very much clear that there would be the common electoral roll. There will be no chance of a separate electoral roll, and if especially on the grounds of religion, race, caste, and sex, there would be no separate electoral roll. On what basis? On the grounds of religion, race, caste, and sex. On the grounds of religion, race, caste, and sex, there would be no separate electoral roll. For example, if there is age, certain people would be with respect to age, there we have the adult suffrage, where you attain certain age, then you can vote. For them, their names would be added, or their names would not be there. Age can be the reason, residence can be the reason. In particular residence, in the electoral roll, your name would be added there. In particular residence, your name cannot be added there. But here, with respect to the religion, race, caste and sex, on these basis, there cannot be a separate electoral roll. Your name cannot be removed from the common electoral roll because you belong to these grounds, or your name cannot be added because you belong to these grounds. So this is what Article 325 talks about. In a nutshell, what does Article 325 talk about? It talks about the common electoral roll. Then we have Article 326. We have Article 326, let me rub it first, which talks about the universal adult suffrage, that every person who attains the age of 18 can vote. Every person who attains the age of 18 can vote. So this is what universal adult suffrage is about. Before 1989, it was 21 years, and after 1989, it became 18. It was reduced to 18 years. So Article 326, it talks about the universal adult suffrage. It talks about the universal adult suffrage. Whoever is an adult can vote. Whoever is an adult can vote. And before 1989, it was 1989. It was 21 years. After the 1989, it is now 18 years. After that, whether you, to which sex you belong to, whether you are a man or a woman, whether you belong to a Dalit community, whether you belong to a Brahman, whether you are a Muslim or non-Muslim, whatever you are, you have this right. Under universal adult suffrage, you have the right. When you attain the age of 18, you can vote. After that, after Article 326, we have Article 327. Article 327, we have the power of here. Article 327, it gives this power to the Parliament to make provisions with respect to the elections to legislative assembly or to the Lok Sabha. What does it say? Power of a parliament to make provisions with respect to the elections, for the Lok Sabha or the Rajya Sabha, or for what? For the legislative assemblies of the state. Similarly, we have Article 338. It gives this power to the legislative assembly of the state to make the provisions for the elections of the legislative council or legislative assembly of that particular state, in case there is no central law. This is Article 328. It is about that. Then we have finally Article 329. Article 329, which bars the courts in the electoral matters. It bars courts in the electoral matters. So what is the reason why we discussed these articles? The point of the discussion of these articles is that to give you the idea, what does the constitution say about the elections, what are the various provisions, what are the various articles which are relevant for your for the elections in India, what does the constitution say? Now let us see. We have Article 329. What does Article 329 say? It says it bars the courts in electoral matters, that in electoral matters the courts should stay away. What is the reason for that? Let's have an idea about. Let's have a little discussion over it. What is the reason for that? Why it has barred courts? Why it has barred courts from the electoral matters? For example, let's suppose right now, let's try to discuss it first. We have Article 329 bars courts from electoral matters. So why it is there. Let's suppose what will happen. There are right now we have the BJP, which does not have the absolute majority. They don't have the majority, the special majority. They are not enjoying this special majority. So let's suppose they will decide that the prime minister, he will consult the president and tell him, please dissolve the legislative assembly and conduct the new elections. And right now the prime minister, he feels that if the election will be conducted right now, he will get the full majority. Let's suppose, and other political parties are not able to, to make the government. Let's suppose this is the condition right now. So the president will call for the elections, and the BJP knows that they are in a position to win the election from everywhere. They may cross the 400 seats also. But the other political parties, they are not in a position to conduct the election. But they cannot do anything much. They cannot do much. So what they will do, they know there are particular states. For example, Telangana is there, Andhra Pradesh is there, Tamil Nadu is there, maybe Karnataka. They know that there are, maybe Karnataka is there, maybe J&K, they are given the status back, Jammu and Kashmir would be there, maybe Punjab is there. They have particular states in which they know they can win. And there are particular states, for example, UP is there, Bihar is there, Gujarat is there, Rajasthan is there. There are particular bigger states, Madhya Pradesh is there, where they know they cannot win. So what they will do, they will, file the nomination papers. And in nomination papers, with respect to these states, the candidates of the Congress, what they will do, they will file nomination papers perfectly without any mistake. And in these particular states, what they will do, they will file the nomination papers with slight mistakes. When they will file it, the returning officer, what he will do, the returning officer will reject the nomination papers in these particular states, and in these particular states their nomination papers will be accepted. Now if it is the case, now what would have been if the courts were allowed to to deal with the electoral matters in the elections? What would have happened? The Congress leaders, they will approach the courts, and there the case will remain for longer time. The courts will give you the dates, and it will continue for a longer time, and in a way they will get the edge, or get their edge, and in these states they may win the election. So in this way they will get the edge. For these constituencies, the courts will continue in giving the dates. So in this way it is going to impact the election. Now that for this reason, to overcome this problem, to overcome this issue, the article, it was very much clear in the minds of the framers of the constitution. So they made it very much clear that they will bar the courts from electoral matters whenever there is elections. Now what can happen? Suppose in the present scenario, suppose if the returning officer will not allow you to contest the election, you have to wait, you will campaign. But once the elections are over, then you can go to the courts. But during elections, you cannot go to the courts. This is one of the reason why there is bar on the courts from electoral matters. Similarly, there is another issue of the delimitation. So let's discuss a little bit about the delimitation too, so that you will have the proper idea about it. Delimitation. What is the purpose of the delimitation? Purpose of it is that every vote should be equal. One person's vote should be equal. One person is equal to one vote. It should be equal. But in our country, and with respect to the population, for example, with respect to the population, there would be the representation. With respect to population, for a certain population, for example, for 10 million population, 10 million would be represented by one person. So this is ideally what it should have been. But in our country, there are different states. There is a state like UP, which is very big, which almost has more than 80 seats in the Lok Sabha, who has more than 80 constituencies. And then we have the Sikkim, who only have fewer constituencies. Now what will happen? In the UP, 10 million are represented by one person, and in the Sikkim, 1 lakh is represented by 10 lakhs are represented by one person, and in Sikkim 1 lakh is represented by one person. So what does it mean? It definitely means that the vote of the person in UP is lesser than the vote of a person in Sikkim. This goes very much against the universal adult suffrage. So for that, the delimitation practice is there, so that as much possible as it could be, there would be the equal representation. There would be the equal representation, and the value of the vote would be almost equal. This is this is the practice of delimitation. This is the idea about the delimitation. And what does delimitation deal with? It deals with the redrawing of the electoral boundaries. Delimitation, it deals with the redrawing of electoral boundaries. Redrawing of electoral boundaries, and the objective is one person is equal to one vote, that the value of the vote from the UP, it should be equal to as much as possible to the value of the vote from the Sikkim. So what does the constitution say about the delimitation? About delimitation, constitution says few things, that after every census delimitation should be done. After every census delimitation should be done, and this delimitation would be done by whom? For that there would be an independent authority, that would be the delimitation commission. They will do this delimitation. If not the delimitation commission, then election commission can also do the delimitation. So with respect to this, first delimitation was done after the 1952 in 1951 census. Second, 1963 delimitation was done. Then third, 1973 delimitation was done. But one thing came to the minds of the South Indian states. It was a time when the states, when we as a country understood one thing, that we have to go for the population control, because the poverty was there. One of the way to control the poverty was to control the population. So with respect to that, the South Indian states, they had done really well. They controlled the population, but the North Indian states did not control it. In 1973, what they did, the South Indian states, they approached the Indira Gandhi. After the 1973 census, they approached Indira Gandhi and said that, ma'am, if you continue to go for the delimitation, it is eventually going to impact the representation of the South Indian states in the parliament as compared to North Indian states. So it will affect our representation, and it will make us just a mute spectator, because the UP will gain huge number of states, the North Indian states will gain huge number of seats in the parliament, and we will just lose it. And even if we will gain, it would not be in proportion. As we are doing great thing, we are limiting the population. So Indira Gandhi understood it, and eventually she put bar on the delimitation. Till 2001 there would be no delimitation. She put bar on delimitation, no delimitation till census of 2001. Even if even if there would be census in 2001, the seats will be frozen. The seats in the parliament will be frozen till 2026. So this was made with respect to delimitation. Until 2001 there would be no census, no delimitation. And if after 2001 this delimitation would be done, but in 2026 till 2026 there would be bar on the seats. The seats would be frozen. But the real question which may come to your mind, what was the reason for the 2001 census, for 2001 delimitation? The reason is very much clear. The first reason why it was done, even though seats did not change in the parliament, but the reason, what is that? First reason was that, first reason for that was the redrawing the boundaries. For example, there is a state which has 3 constituencies. Every constituency with 1 million population will have one representation. Here also 1 million population, one representation, 1 million population, one representation. But eventually by time the population has increased. But let's suppose it has increased unevenly. In this constituency it has reached 10 million. In this constituency it is 3 million. In this constituency it is 6 million. Now total 18 million. Now what did we did in the 2001 census? After 2001, in the 2001 delimitation, we did not change the representation. What we did, we adjusted this state in such a way that every constituency had got equal number of representation. For example, we redrew the boundaries. For example, we gave this constituency 6 million. In such a way, we created this constituency in a 6 million constituency, which would be represented one similarly for this 6 million and similarly for this 6 million. So in this way, we had redrawn the boundaries, but but the seats were kept very much frozen. So this was one of the reason. why delimitation was done in 2001. And second reason, to increase the number of seats reserved for SCs and STs. The second reason was to increase the seats reserved for SCs and STs. For that reason, the delimitation was done. Now we know that the delimitation can't be done. After 2026, what census would be conducted? After that, the delimitation would be done. But still, we had seen the cases with respect to, in 2002, the delimitation was done, and finally the award was given in 2008. But still, we had seen has been delimitation in Assam, which was conducted by the election commission, and there is a delimitation was there in the J&K, which was conducted by the delimitation commission. So isn't it violation of the constitution? The matter went to the court, and the court said that what are your queries? First question was asked, if there is no delimitation till 2026, why in J&K and Assam, and why the number of seats also increased? If the number of seats are frozen, why the number of seats also increased? And the second question was asked, why J&K exercise was challenged. About delimitation, we should know that, as we are discussing, why there is bar on the courts. As we saw that with respect to the electoral matters, delimitation is also an electoral matter, and there is a bar on courts. Courts cannot decide about the delimitation. So the question with respect to Jammu and Kashmir, as this was challenged in the court, so there another question is why it was challenged in the court. And then the third question, what should the South Indian states do with respect to if the delimitation will happen after 2026-27 census, which the dates had already been decided? What South Indian states could do with respect to that? What will happen to them? Let's try to answer these questions here. So with respect to Jammu and Kashmir, the courts said very much clear that prior to 2019, Jammu and Kashmir, prior to 2019-18, 18-19, Jammu and Kashmir was clearly a state with a special status. Their delimitation was very much different. But after that, it has become a UT. Now delimitation center, whenever center wants, they can do the delimitation. It is not bound by this. This freezing of the seats is bound with respect to what it is bound for. It is for the states, not with the UT. And also its representation has been its representation its representation in the legislative assembly has remained almost same. Its representation has remained almost same. The number of seats for the J&K has increased only by 1, and the number of seats for the Kashmir increased only 1, and the number of seats for the Jammu, it increased 7. But with respect to its representation, it has remained frozen. Then the second question was why it was conducted. Why, even if we will see what is the criteria for the delimitation. The criteria, originally it was understood, it was believed that the original criteria would be the population. But the Supreme Court said that if the population was the criteria, then how Jammu their representation increased to 7, 6 by 6 numbers, and in Kashmir, which has the larger population than Jammu, its representation increased only by 1 number. How it was possible? So this question was asked to the Supreme Court. This question was asked, and the answer was that population is not only the sole reason for the delimitation. The areas closer to border, it is also the reason for the delimitation. If there is hilly terrain, then this is also the reason for the delimitation, and population is also the reason for the delimitation. Then question, why it was carried in Jammu and Kashmir? Because it is not state anymore. In UT it can be carried out. And then the question about Assam, why it was carried in Assam? Because when the delimitation order was given in 2008, there were few states which did not accept it. They protested against it, and those states are Assam, it is Arunachal Pradesh, it is Manipur, and Nagaland. They did not accept those awards. So with respect to this, Assam protested in 2008 and did not with respect that They did not use the 2001 reform. They did not use the 2001 reference, and finally, they did not wanted to use the 2001 reference. What was the reason for that? Because in 2001, if they would have used the 2001 reference, it would have included the illegal migrants too. So for them and for the Assam, this delimitation was conducted. And with respect to other states, maybe they will also conduct the delimitation. This is why there has been delimitation, even though there was ban on it. That is the reason why the Assam and Jammu and Kashmir went through the delimitation. We can see the delimitation in Arunachal Pradesh also, in Manipur also, and in Nagaland also. But now, census dates are there. Let's see what will happen after that. It is till now, I guess everything is very much clear. Now the real question may come to your mind about how it is going to impact the South Indian states. You know, with respect to South Indian states, as what they did, they restricted their population. Their population has reduced, or it has remained constant. But the population in the North Indian states, it has jumped exponentially. Now, if the population is the criteria of the delimitation, then definitely, if the seats would remain unchanged, if the seats would remain 543 only, then definitely the South Indian states, as we believe in one vote should be one person is equal to one vote, then definitely by following this principle, the seats in the South Indian states, they will lose their representation, and in the North Indian states, they will gain their representation. For example, UP will gain representation, Bihar, and all these states. And now, if this number will not remain frozen, if it is changed, if the number increases too, if the representation in parliament increases too, then how much increase we will see in the South Indian states? It would be very little, and in the North Indian states, it would be very huge exponentially. So what will it lead to? It will lead to an edge to the North Indian states. For any government to come into the, for any political party to come into the government, they will just have to take care of few states and they will win the elections. So this is the issue with respect to delimitation. Now what can be the solution for that? And the solution to solve this issue, what can be the solution? The solution can be of two types. One, freeze the number for next 30 years or 50 years. This can be the one solution, or freeze it forever. And the second solution can be leave it to the future, and hopefully they will decide over it. Freeze it for 50 years, or freeze it indefinitely, or leave it for the future. Let the future generations decide how they will want to deal with this issue. This can be the solution. So the real point why we took up the delimitation here is that according to Article 329, what does Article 329 say? That it bars the interference of the courts in electoral matters. And with respect to that, we saw how in nomination it bars it. With respect to the delimitation, how courts cannot interfere with respect to the order of the delimitation. But courts still, there are cases with respect to Jammu and Kashmir, it was there. It was not over the courts were not deciding over the order of the delimitation, but they were deciding on whether delimitation should have been conducted or not. The question was different, not on the order of the delimitation. Now let's try to discuss. As we saw we saw how the constitution deals with the elections. Now let's see what does the election commission consist of, what is its role, and how it how it has reshaped the elections in India, and how it impacts the politics in India. Let's try to discuss that now. Let's try to discuss election commission of India. What does the constitution say about the election commission of India? Constitution says there shall be election commission of India. First, there shall be election commission of India. Second, it shall consist of chief election commissioner, shall consist of chief election commissioner, and as many election commissioners as determined by the president, by the president of India. So the constitution is very much clear that there shall be the election commission and there shall be the chief election commission of India. It shall consist of election commissioner, chief election commissioner, and as many election commissioners as determined by the president of India. Now the question may come to your mind, how they would be how they would be elected, how election of commission would be there, how the members of this election commission would be elected. For that the law says, for that the constitution says, for that law shall be passed by the parliament. Law shall be passed by the parliament, but unfortunately till 2023 no such law has been passed by the parliament which deals with how these election commissioner or chief election commissioner should be elected. So what was the practice, or what is the practice with respect to the election and chief election commissioners? Till 1989 there was only this election commission of India. It was a one single member body which consists of the chief election commissioner. There was no other election commissioners. But in 1989 when there were elections, two more election commissioners were added. Two more election commissioners were added, were appointed. Two more election commissioners were appointed, and after the elections were over, it was again made the one member body which consists of chief election commissioner. Why these two more election commissioners were added? Because the population of the country has increased so much that now the chief election commissioner cannot solely do his function. He needs assistance. For the assistance purpose, using this article, using what the constitution says that there shall be the chief election commissioner and as many election commissioners as possible, using this provision, two more election commissioners were added, and then again it was reversed. Then eventually in 1991 the Election Commission of India, Conditions and Services of Election Commissioner and Transaction of Business Act of 1991 was framed. So what? Let me rub it first. In 1991, when there was no such law which deals with the which deals with the how the election commissioner and election commissioners will be nominated or elected, or how they will occupy their place in the election commission of India. Eventually in 1991 a law was passed by the parliament which is election commissions of India, election commission of India, conditions of services of election commissioner and transaction of business Act of 1991. So this act was formed by the parliament, and it was amended. It was again amended in 1993, in which the election commissioners were also added. So the matter went to the court. It was T.N. Seshan who was the chief election commissioner then, and he went to the court. He said that, sir, the government is adding these two election commissioners so that it will keep check on me. It will restrict my powers. But the court did not accept this plea. Court said that, look at what does the article say, that their article is very much clear that there shall be the election commissioner of India. Election commission of India, it shall consist of chief election commissioner and as many election commissions as determined by the president. So government is right in making this provision. So this provision was made that election commission of India, under this amendment, election commission of India will consist of chief election commissioner and not more than 4 election commissioners, not more than 4 election commissioners. This was finally which was adopted in 1993 by the Constitutional Amendment Act. And eventually, the matter went to the court, and courts did not accepted it. Now, eventually in 1991, this law was formed and it was challenged in 1993, and eventually it was amended, and it was amended in 1993 when it was challenged to the court. The courts did not rejected the plea, and it was said that it is very much constitutional, and finally the number changed. It is Election Commission of India. Commission of India will consist of chief election commissioner and not more than 4 election commissioners. Now the question is, who is going to appoint them? Eventually it was the recommendation of the president. On the recommendation of the prime minister, the president would appoint them. But it was very much clear that there should be a law. Now, eventually, what happened that in in 2023, the matter went to the court, and in Anu Barnwal versus the Union of India. So the name of the case is Anu Barnwal versus Union of India. Matter went to the court, and questions were asked to the Supreme Court. Questions were asked to the Supreme Court. First question, sir, it violates the how the election commissioner and chief election commissioners are elected. It violates what? It violates Article 14. It is very arbitrary in nature. Second, and there should be the rule of law, as Constitution says that the Parliament should make law with respect to the appointment of them. But there is no such rule. There is no such law. Then definitely there is the lack. There is violation of the rule of law. So with respect to this, what the court said? Court said, don't worry till the Parliament will enact the law with respect to their appointment. Let us bring up the solution. So the court said that till the Parliament will enact the law, the Chief Election Commissioner and the Election Commissioner should be appointed by a committee, and this committee will consist of the PM, it will consist of the Chief Justice of India, and it will consist of the Leader of Opposition. Till from the day Constitution was enacted till 2023, till this judgment, never such law was passed. Once the Supreme Court interfered, then what did the government did? They enacted the law. And the name of the law is the Chief Election Commissioner and Other Election Commissioners Appointment, Conditions of Services and Terms of Office Act 2023. What is the name of the law? The Chief Election Commissioner and Other Election Commissioners Appointment, Conditions of Service and Terms of Office Act of 2023. It was brought in, and what it did, it replaced the Act of 1991. It replaced the Act of 1991. Here you can say that, sir, it is contradictory to the statement you made just few minutes before, that there was no such law with respect to this till 2023. Where from this 1991 Act came in? This 1991 Act deals with the transaction of business. It deals with the conditions of service. It did not dealt with the appointment. So it was replaced by the Chief Election Commission and Election Commissioners. Commissioners Appointment, Conditions of Service and Terms of Office Act of 2023, which will deal with the appointment. It will deal with the terms of office. It will deal with the conditions of service. Everything will be dealt in this act. So finally, this act was brought in, and it replaced it, and it also gave the committee which will appoint the election commissioner and chief election commissioners. Who would be the members of that committee? Who would recommend it to the president? Who will be the members of the committee? The committee will consist of prime minister. It will consist of leader of opposition in Lok Sabha, and it will consist of the union cabinet minister. So this would be the composition of the chief election. Though it will be the composition of the selection committee. Will this selection committee just give the name to the president? No. For the selection committee, names would be decided by whom? Names would be decided by the search committee. Before selection committee, it would be discussed by the search committee, which would be headed by the Union Ministry of Law and Justice. Union Ministry of Law and Justice, they will with a few members, this will consist of search committee, and they will decide over few names, and they will send it to the select committee, and this select committee will further send its recommendation to the president, and finally the president will elect. And after that, it also, as I told you, it also deals with the terms of office, service conditions and all that. What would be the eligibility criteria for a person? Eligibility criteria for a person to be elected as a election commissioner or chief election commissioner. He should be a person of integrity. This act says person of integrity. He should have the knowledge and experience in the management and conduct of elections, and also he should be or have been secretary or equal to the government or equal to that post. He should be the secretary or have been the secretary or is equal to that government post. If these criteria are fulfilled, then his name can be recommended by the search committee to the selection committee, and selection committee will choose one among them and they will refer it to the president, and finally president will appoint that person. So this is what is the criteria for appointment. Then we know that who is the committee, we know that who is the selection committee, we know that who is the search committee, what consists of the search committee. Then what is what would be the what would be the salary of these election commissioners and chief election commissioners. Salary would be same as the Supreme Court and High Court judges. And what would be the term would be 6 years or 65 years, whichever is earlier. Either 6 years or 65 years, whichever is earlier. How would they be removed? If it is the chief election commissioner, he would be removed as same as the judge, same as the High Court judge. If he is the election commissioner only, then the advice opinion on the opinion of the chief election commissioner, he can be removed. So these are some conditions, some important provisions in this act which was brought in 2023. So let us see, it still needs some certain reforms. Now let us discuss what are the various reforms which are needed with respect to this election, with respect to this act, act of 2023. What are the reforms needed? First, it should replace union minister in selection committee with the eminent person. Replace union minister with eminent person. And who would be this eminent person? He would be chosen by Chief Justice of India. He would be chosen by a committee consisting of the Chief Justice of India, Prime Minister, and the leader of opposition. It is a recommendation. Second, other chief election commissioners should also be removed, same as the other election commissioners should also be removed as same as the chief election commission. There should be no discrimination. If there is no discrimination, then they can work independently. If they are so much dependent on the chief election commissioner, then they will follow his commands. They will just follow his commands. They will not have their independent opinion. This is the second condition. Then the third, there should be a cooling period. What is this cooling period? After they retire, they should, for 3 years, they should not be allowed to join any government job or join any government office. After 3 years of their retirement, they should not be allowed to join any government office. Then the fourth, after they retire for 10 years, they should not be allowed to join any political party. So these are the recommendations which are given by the election commission itself, that these recommendations should be brought in. So with this, I hope you had understood the election commission. It is how its creation, how it was a single party for a larger time period. Then in an election in 1989, it became election commissioner was added with chief election commissioner was added with 2 election commissioners, and eventually in 1991 election commission of India conditions and services of election commission and transaction business act was brought in, but it was replaced by the 23 act. And we understood every discussion which was important with respect to this topic. Now with this, let us see what are the powers, what is the role and function of the election commission of India. Let's try to understand that. What are the powers, roles and functions of the election commission of India? Roles and functions of election commission of India. First, what does the constitution say? Constitution says the election commission of India will superintendence. His role is of the superintendence. His role is of the direction, his role is of the control, and his role is of the conduct of the elections. It is all vested in the election commission of India. So in this regard, to give the superintendence, to direct the elections, to conduct the elections, to control the elections, the election commission of India came up with 2 rules. One was in 1961, they came up with the 2 rules. In 1960, first one is election conduct rules were made by election conduct rules of 90 election conduct rules of 1961 and the symbols order. symbols order of 1968. But this was challenged once in 1961 to have this to have the superintendents, to have the to have the directions with respect to elections, to have the control over elections, to conduct the elections. They brought up two rules. One is election conduct rule of 1961 and the symbols order of 1968. But both of them got challenged into the Supreme Court. They got challenged, and the name of the case is Kanhaiya Lal Umar versus R.K. Trivedi. Please remember this name. Kanhaiya Lal Umar versus R.K. Trivedi. And the questions which were asked to the Supreme Court, the questions which were asked to the Supreme Court were that how the Election Commission of India can deal with the assigning with the symbols. They can withdraw these symbols. It is beyond their power. Then to this, the Supreme Court said, look at the Constitution, look at the Article 324. What does it say? It says that the Election Commission of India has the superintendence. It has the direction. It can control. It can conduct the elections. It has this power. It can do it. But in case there is any law, then the Election Commission of India cannot supplement that law. If there is no such law, if we have the Representations of People Act 1951 and 50, but that did not deal with this. So let the Election Commission of India decide over the symbols. Let them decide over whom they will assign as the national political party, whom they will assign as the regional political party. It is up to them. But if there is any law, then they cannot supplement them. If there is no such law, they can do whatever they can do it. So eventually, with respect to this, what are the powers? It is the power of the superintendents, power of the direction of the election, how the elections would be conducted, control over the elections, and conduct of the elections. So with respect to this, earlier, what used to happen? The elections would happen by the ballot paper. And the elections would happen by the ballot paper. Elections would happen by the ballot paper, but eventually in 1982, there was a constituency in Kerala by the name of Parur constituency. There was a by-election, and for that by-election in the Parur district, in the Parur constituency of the Kerala, this by-election was conducted by the use of the EVM. It was challenged in the High Court and in the Supreme Court. And you know what Supreme Court said? Supreme Court said, follow the law. We have the Representations of People Act, and it says that elections should be done by the help of ballot papers. The Election Commission of India said, sir, look at Article 342. We have superintendents, we have direction, we have control and conduct. The Supreme Court said to Election Commission of India, please, I know that, please shut up and look at the Representation of People Act. You have to do it through the ballot paper. And this election was nullified, that this election is not valid. The by-election was declared void. So eventually, similarly, this is why I brought this example, because at one place, when there was no such law, when the law formulated by the Parliament did not discuss it about it, then the Election Commission of India, with respect to the superintendents, with respect to direction, conduct and control, they can bring in the laws. But if there is law, then they cannot supplement those laws. Similarly, in Gujarat, we have the case of the Gujarat, when there was when there were riots in the Gujarat. Narendra Modi became the chief minister, and he asked the governor to dissolve the government, and finally the government was dissolved. So what happened after that? They asked for the election. The Election Commission of India did not conduct the election. When he did not conduct the election, now what was the option available to them? Some of the state government, the central government, they also wanted the Election Commission to conduct the election. Commission did not conduct the election. So what were the options available to them? They checked the section 14 and 15 of the Representation of People Act 1951. We said that in Lok Sabha, if the Election Commission does not conduct the election, then the President, and in the Legislative Assembly, the Governor can notify the elections, then Election Commission will definitely conduct the election. But once they try to do it, president and the governor, this matter went to the courts, and the court said it was referred to the court. It was basically, this matter was referred by the president to the court for its advice under Article 143. The Supreme Court said that no, you cannot do it, because for conducting the election you need the permission. For this notification you need the permission of the Election Commission of India, so you cannot conduct the election. Then the Supreme Court asked the Election Commission of India, why you are not conducting the elections in the Gujarat. The Supreme Court said that look at the situation in Gujarat. The people had migrated, they are living in camps. There is no, what is the purpose of the election? To ensure adult suffrage, to universal adult suffrage. Everybody who is capable of voting, who has attained the voting age, he should vote. But in Gujarat, the tensions are very huge. People are not there. If we will go for the elections, it will not satisfy anything. So then that's why we are not conducting elections. The Supreme Court said, okay, this is the reason, accept it. But after you dissolve the assembly, within 6 months you have to conduct the elections, then you should conduct it. So this is the why we are discussing this. This is the power of the Election Commission of India, that even though without their notification, if without their will, no notification about the election can be done. It is up to them. So this, they enjoy the huge power in it. Also, their another power is they recognize the political party as national or regional. They will recognize whether the political party is national or regional. That we will discuss in tomorrow's discussion. What would be the criteria for a political party to be the national political party, and what would be the criteria for a political party to be the regional political party, that we will discuss. And also it will resolve the dispute. It will resolve the matters related to split. For example, if a political party will split, who will get the election symbol, who will get the party name? In such matters it will deal with. For example, there is a political party, they will have their own constitution, and in that constitution they will have the organization wing, they will have the legislative wing. So with respect to this, once a political party will go through this split, the Election Commission of India will look at their constitution, they will look at the organization wing, they will look at the legislative wing, and whoever part has the majority in the legislative wing or the organization wing, that party, that portion of the party will get the symbol, and that portion of the party will get the name of the political party, original political party. For example, we can take the case of the Shiv Sena. We know it's split. At one side we have Eknath Shinde, and at the another side we have the Uday Thackeray. When they split, the matter went to the Election Commission of India. They saw that they only checked the legislative, legislative wing, which section has the majority, and it was definitely the Eknath Shinde's section which has the majority, and it got the name and the political symbol. So it deals with it. It deals with the in matters of the politicals, in matters of the Election Commission of India, it deals with the matters of the split. And also the Election Commission of India, its another power is it advises president or governor on disqualification. It advises president or governor on disqualification, whether to disqualify a person or not, except those which we discussed in the 10th schedule anti-defection law. What are the other criteria for disqualification? For example, if anybody has done fraud in attaining the citizenship or any other ways, so or is not of a suitable mind, then they can, Election Commission can give the advice to the president or the governor of the state. Now with this, these are certain powers of the Election Commission of India. Now let us see what is the process of the election, how election is conducted, what are the various important concepts which we need to know when the election is conducted. Let's try to understand that. When there is election, election process, in the election process, the first and most important thing is, in the election year, the electoral rolls are updated. Electoral rolls are updated. So with respect to this, when the electoral rolls are updated, here right now there is a big concern with respect to Bihar assembly elections, where the Bihar government has gone for the intensive updation. before, prior to 2003, those who were added into the electoral roll, they will not have to verify. Post 2003, they will have to verify. So there is a concern with respect that many people had migrated, they would lose their right to vote, they will lose their right under the universal adult franchise. And the reason for that is to end the duplication, to end to end the duplication of the votes, and to end the bogus votes, and also to refresh it. Who had died, they will be removed, and who are new voters, they would be added. But right now this is under concern, and the question is being asked about this electoral rules. Now you can again ask this question, sir, it is an electoral matter, why? And the constitution is very much clear that under article 329 that such matters cannot go to the court. Why this matter is in Supreme Court? Well, the question is not about the electoral rolls, who are the added, or who had been missed about in it. The question is why, when it is being conducted, the time period given for that, the documents which are required for that. The question is with respect to that, not for the whole exercise. That's why it is in the matter is in the court. So the first thing, electoral rolls are captured, and the reason for as is to add, to refresh, to update the electoral rolls. Who are the new voters, they are to be added. Who are the voters who have died, they have to be replaced. Maybe any voter, he has changed the citizenship, he has to be removed from the electoral list. After that, once the electoral rolls are prepared, then dates would be announced. Dates would be announced by the election commissioner and election commissioners, chief election commissioner and election commissioners. And in case of the dates about the elections, the election commission of India is not bound by the advice of the government. After the dates are announced, the model code of conduct is implemented. And in this model code of conduct, it will remain till the results are there. And in the model code of conduct, there would be election notification would be there, campaigning would be there, voting would be there, and counting would be there. Till the results are there, model code of conduct would be there. Now let us put some light on the model code of conduct. What is this model code of conduct? This model code of conduct is not something which came by the law. It is something which was adopted by the politicians, the Democrats, the great Democrats. They adopted it on its own, so that there would be the fair space for the people to conduct the elections. There would be the fair space to the opposition. There would be the fair space to the politicians to conduct the elections. So let's see what this model code of conduct is. Model code of conduct. It was in 1952 when there was first elections. PM Nehru wrote letters to ministers, please separate election work with the official work. PM Nehru, he wrote letter to his ministers that separate election work from the official work. What was the reason for that? Suppose for an election, to conduct an election, you need lots of amount of money, you need vehicles, you need to campaign. And when you are in opposition, when you are not in government, you have a limitation on the money, how much you can spend. But when you are in a government, you don't have the limitation. You have the cars are available to you, vehicles are available to you. So in this regard, there is an imbalance in the election. We cannot say that it would be fair that the governing political party will enjoy the advantages. So with respect to this, the PM Nehru, he said to the ministers, please do one thing, ensure that there is level playing field, ensure that when you are going for the official work, just do the official work. When you are going for the electoral campaigns, separate your electoral campaigns, election works with the official works. This was his first statement in 1952 with respect to the fresh elections, so that the level playing field would be maintained. And also the ruling political party, they have this light edge, they can get funds from the public fund, and they can enjoy it. So with respect to that is the reason why they gave it. And eventually it was first in the Kerala. In Kerala, whenever there used to be elections before this incident, there would be the two candidates who would be fighting elections against each other. There would be the supporters of one candidate. he for A candidate and there is B candidate. When they will they will go for the election campaigns, the supporters of B candidate will interfere here, and there was always chaos, and it was the issue in the elections. And all the political parties in Kerala, they understood it. They understood this thing, that it is eventually impacting the people, it is eventually impacting them on equal basis. So what they decided that can we have a minimum code to govern all political parties in Kerala. They decided that can we have the minimum code to govern all political parties. Can we have a minimum code to govern all political parties? We are disrupting each other. Can we stop it? All of us will agree on certain points, and this minimum code will be known as the model code of conduct. And eventually it was adopted in 1962 election commission circulated same model code of conduct to the other states. In 1962 itself, Kerala, West Bengal and Tamil Nadu followed it. Kerala, West Bengal and Tamil Nadu followed it. Even Tamil Nadu went to the another extent. They formed the committee which consists of the members from each political party, and they will keep check on the election campaigns. They will keep check on the political parties whether they are following the model code of conduct or not. And eventually in 1979, the comprehensive model code of conduct was formed, and the reason was to in 1979 the complete model code of conduct was formed, and reason for that was to ensure that there is level playing field. And this model code of conduct, it will be there once the dates would be announced, till it remains jail till the declaration of the results, to ensure that there will be the level playing field. What are the provisions? There are certain provisions which are equal to both political party in power as well as other political parties. For example, don't provoke people on the basis of language and religion. Don't criticize policy, just criticize the policies, not the private life. Don't use the mosques, gurdwaras, temples and churches for the political campaigning. These are for all. The few provisions are for all political parties, but for the political party in power, they have other provisions too. What are those? They cannot make new policies and programs when election dates are announced. At that time they cannot come up with the new policies and programs. They cannot use money from the public fund in advertising for the advertisement. And also they had put a limit on how much a candidate can spend in the election campaign. So various provisions had been brought through the model code of conduct. But the real question is it really followed? The answer to this is the big no. It is not being really followed. Why it is not being really followed? The reason for that is why it is not being really followed, because it does not have a statutory backing. It does not have a statutory backing. And another thing, election commission of India wanted it to have a legal backing, but eventually they realized that in model code of conduct there are various provisions, for example related to bribing the voter, causing enmity, causing secrecy of violating the secrecy of the votes, or threatening voters and candidates. It comes under various other acts, criminal acts, which has the well defined punishment. So eventually the election commission of India decided that they don't want this statutory backing to the model code of conduct, and that is the reason why it is not religiously followed. What will happen if you violate model code of conduct? Nothing will happen. We had the elections recently. We know that what were the statements made by the different politicians with respect to each other's personalities, with respect to communities. Nothing happened to them. So it is very much clear, nothing will happen if you violate the model code of conduct. If we want it to be there, then it should have a strong statutory backing, and the election commission of India should be very much strong. So after the model code of conduct, now we have the electoral rules. We discussed that they are to be updated, so that we can refresh it. Who are the people who are not part of the constituency now, who had migrated, we will know about them. Who are the new additions, we will know about them. Who are the people who had died, we will know about them. We will try to reduce the duplication and bogus voters. After that, the nomination papers would be signed. I want to, for example, if a person wants to contest the election, get signed and submit it to the returning officer, and then they have to subscribe the oath under the third schedule of the Indian Constitution. Then after submitting the oath, they will be given certain time to withdraw the to withdraw its nomination paper, and this is given so that whether he was in sane mind when he filled his nomination paper, whether he really wanted to contest the election or not. Then the elections are finally conducted. Now, when elections are conducted, what are the various ways the elections can be conducted? Earlier we used to follow the open ballot system, ballot system. We used to have the closed ballot system, and it was replaced by the EVMs. This ballot system was replaced by the EVMs. So what are the different characteristics which in which order this election would be conducted? What are the characteristics of the what should be the characteristics of this voting machine? If it is open ballot paper, what should be the characteristics? Let us try to find out the characteristics of the voting machine. First of all, it should be accurate. It should be accurate. If I am voting for BJP, this vote should go to BJP. It should not go to the Congress. It should be very much accurate. Second, there should be the anonymity in it. Anonymity should be in it. Nobody should know whom I voted for. Why should anybody know that whom I voted for? It can cause various issues with respect to that. Similarly, the third is scalability. It should have the capacity to hold for the 80,000 voters, 80 lakh voters, or 8 crore voters. It should have the scalability. And fourth, it should be done in a very little time period. It should have the speed. If these characteristics are in any voting machine, then we say that voting machine is very good. So earlier what we used to follow was the ballot papers. Now it got replaced by the EVMs. We know that it got replaced by the EVMs. First it was used in a constituency in Kerala, but it was made unconstitutional. But eventually, since 2004, earlier it was actually it was recognized by the Representation of People's Act. Then since 2004, only EVMs are used. Who manufactures this EVM? It is manufactured by the Bharat Electronics Limited and the Electronic Corporation of India These two public sector companies, they manufacture the election EVMs. And these EVMs, they have two units. One is control unit, and then another is ballot unit. This control unit, why it is there? In this control unit, can the presiding officer, anytime he can switch it off if there are rowdies they are trying to attack the booth. They can switch it off, and they can for curbing the election frauds. They need the presiding officer to push the start button so that another person will vote. So because of that, they have the control button, which is under the control of the presiding officer, so that there is least malpractice, there is least cheating in it. And why EVMs replaced the election ballot paper? The major reasons were, in the ballot papers we used the papers for the papers we need to cut the trees and eventually pressure on the environment. So EVMs are environment friendly. EVMs are for ballot papers we need to in counting it would take a lot of time. EVMs can do it automatically. It is very quick. And third, it can EVM in the ballot papers there were chances of the booth capture. So EVMs, what they do, they eradicate the booth capture. So in the EVMs we have, as we discussed, we have start button and the stop button. It is controlled by the presiding officer. So in this way it solves these issues. But even though the EVMs have these issues, but still there are various problems related to EVMs. If we look at India and other countries, other developed countries, for example, we have USA, we have UK, we have France, we have Germany, we have Netherlands. In USA, only few states had adopted EVMs. Others are, still going for ballot papers. In UK and France, they don't use EVMs at all. In Netherlands, they had never used it. In Germany, they had called it is unconstitutional. Why it is unconstitutional? Because there is the lack of transparency with respect to the EVMs. With respect to EVMs only, if you vote there, you don't know whether you voted for the right person or not. So because of these issues, there are certain issues related to it. And there are allegations that EVMs can be hacked, but that is not the case with respect to Indian EVMs, because it acts as an calculator. Because Indian EVMs are perfect, they don't have the transmitter and receiver, so they cannot be hacked, they cannot be connected to the internet. EVMs, the issue with the EVMs is they cannot be hacked, but there can happen, the malpractice can happen with the machines. But for that we have a solution: we can replace the machine. And also, how the elections can be rigged with respect to EVMs, then definitely it is not the machines which have the problem, it would be the problem of the management. The management would be corrupt, then only it can be rigged. So with respect to this, as I told you that Germany has made it unconstitutional. Why? The reason for that was because it is not that transparent. To overcome this issue, the Supreme Court directed that there should be the VVPATs also. VVPAT should be also there. Voter verification paper audit, trial should also be there. VVPAT should also be there. So the VVPATs got added when once you vote, for the 7 seconds on the screen, on the VVPAT screen, the serial number of the vote would be highlighted, name of the candidate and symbol of the for which election political party you voted, and then the slip will cut automatically and drop into the box. So this VVPAT got added with EVM. So please know what are the things which are represented on these on the slip. It is the serial number of the vote. This question can be asked because recently we had elections, name of the candidate and the symbol of the election political party which you had voted for. Then again, now there was another concern that okay, I am voting and it is showing the same, but what if there are malpractices? So let me the people approached, there were questions, there should be cross check, and eventually the election commission said that one VVPAT should be, during elections you are allowed to check one VVPAT in an assembly, in a constituency. In assembly constituency you can check one VVPAT and then you can get satisfied. But still there were few people who did not got satisfied, like Chandrababu Naidu. What is the sample here? It is very much arbitrary. They went to the Supreme Court and Supreme Court said instead of one you can check, now you can check 5 VVPATs, and still people are not happy with it. So there is an NGO, or we can say the ADR, the Association of Democratic Reformers. They are not satisfied. They went to Supreme Court and asked Supreme Court 3 questions with respect to EVMs and VVPATs. First, there should be 100% verification. Second, we should go back to the ballot papers because there are issues, people are not satisfied with it. Third, there should be the physical copy to voters should be given on which they had voted. So the Supreme Court, when heard this, the Supreme Court rejected all the 3. They rejected the 100% vote verification. Supreme Court rejected back to ballot paper. It also got rejected, and physical copy to voters, it will in a way impact the voter itself. It can create issues of transparency. It can create issues of people will know which party he has voted, and eventually he will be under huge pressure. So with respect to this, the Supreme Court said, let's suppose now and there is a candidate who has lost the election, whose position is second or third. He will then what should be the option available to him? He will go to the Supreme Court and ask for the 5%, ask for this verification. Supreme Court will give him the 5% VVPAT verification would be allowed for him, but this much the money he will have to spend on his own. The money involved in this matter he will have to spend this money on his own. If there is malpractice, then there would be new elections and the money will be given back to him. Then simply another machine which is associated with the EVPATs, it is symbol loading unit. This symbol loading unit is after elections, after results. This is for this reason, for maybe any candidate will file the complaint, for him this symbol loading unit, after every election it is kept as it is for 45 days. Nothing is done to it, nothing is done with respect to the symbol loading unit. So this symbol loading unit, it comes into picture when any person wants to recheck it. Then after that, there is another question that EVMs violate secrecy prior to that this EVMs, they violate secrecy. How they violate secrecy? That when once the counting is happening, that the candidate is watching the counting and he comes to know that which constituency has voted less for me and which constituency has voted more for me. So there is, with respect to the secrecy, there is a claim that Election Commission of India should add totalizer too, so that all the EVMs will be connected to the totalizer, and when the counting would happen, nobody will know which constituency has voted for them and which constituency has not voted for them. Election Commission of India likes the totalizer, but it is the political parties which are against it. So with this, our today's discussion is over. I hope you would have liked the video. There was very much with respect to the prelims preparation as well as mains preparation. If there is any confusion, please do write in the comments. We are here to help you guys. With this, thank you for staying with me. Thank you very much and have a nice day.